We're going to be discussing the role of a fiduciary, which most people don't understand. In fact, I think it's very interesting if I ask a client who's a fiduciary for them, the first answer is a banker, and I try to keep a straight face because the banker is probably the opposite of being a fiduciary. The second one they usually mention is their broker at Schwab or Merrill Lynch, and I really fall apart on that one. So we're going to be discussing who is a fiduciary in this session and what the role is, and I think you're all going to learn something. In fact, I learned something, and I'll tell you when we get there. Our objectives. By the end of this module, you'll be able to discuss the various definitions, interpretations of the term fiduciary. Again, there's no definition, and it really applies on what your job is, in many cases, or what organizations you belong to. Describe which professions are by definition fiduciaries. Understand the purpose of the Uniform Trust Code, and describe the basic accounting rules of a fiduciary. With that, let's start. This is the definition from Black's Law Dictionary. It's let you read it on your own, but basically it's a very old rule. It came from cases back in the 1800s, and again, Black's Law Dictionary is what you're going to see lawyers use in court when they're using the typical definition of a trustee, which is probably the one that you're going to run into the most. It would not be applicable, for example, for a financial planner because, as we'll see later, they have a different requirement. And again, let you read it on your own. I want you to just see it. Here's the definition for a fiduciary from the Legal Terms Dictionary. This does not have the credibility of the Black's Law Dictionary, but is used by the various courts as well as lawyers as an alternative to Black. In other words, if Black doesn't have the answer you want, you to sometimes go to this one, which is a little bit easier to understand, I think, in that the major part here is there's no conflict between the fiduciary and the principal, and the fiduciaries cannot profit from the position unless the principal consents. That's probably the big difference between it. Then we have, the CFP Board of Fiduciary. This is where it gets to you, the financial planning recommendations, which are services and products that are reasonably believed to be the best possible options available to their clients. That's from the board. Then we have the California State Board covering professional fiduciaries. A professional fiduciary in California is any trustee or executor who is not a family member of the grantor or deceased. In this case, a fiduciary is a person who assumes responsibility for a position of trust. The fiduciary's trustee has the responsibility of carrying out the terms trust is set forth in the trust document. So the fiduciary responsibility here is to do what's in the trust document. So again, each of these have a different definition of what a fiduciary is. Now, who are fiduciaries? The one that most people are surprised on is the physician. And lawyer is another one. People say, my lawyer is my fiduciary. Yes, they are. CPAs, trust officers, certified financial planners, but not financial planners who are not accepting a fiduciary responsibility. Registered investment advisors, but not brokerage house employees. The NAFPA registered financial advisor, and fiduciary professionals who aren't bankers, and that shocks 99% of my clients. Insurance agent, that's another one that surprises most of the clients. The registered reps or brokerage, and quite honestly, the clients don't know the difference between a registered investment advisor and a registered rep. Debt advisors, real estate personnel, sales persons, and tax preparers. Now, a real estate personnel have a fiduciary responsibility to the seller, and it gets a little bit complicated, but they're not a fiduciary per se. And tax preparers are not a fiduciary per se either. However, they have certain responsibilities that are covered by the Circular 230. The Uniform Trust Code is what's best in effect is saying what are the duties of a trustee who has fiduciary duty. And by definition, they have fiduciary duty as a trustee. Now, if you're handling assets in a trust, then there's your prudent investment advisor rule comes in, which we'll talk about later. But for the purposes of any trust, the Uniform Code provides a comprehensive model for codifying the laws of trust and their fiduciary trustees, and is used over half the states. Many states, however, have made adjustments to it because, like uniform codes, and that could be the Uniform Probate Code, the Uniform Trust Code, the Uniform Probate Penal Code, Uniform Commercial Code. It's a guideline prepared that is a recommendation for states to use. They're not required to use. But if there's in doubt, people look to the Uniform Code. Since, as a practical matter, all states use some part of it, I've listed the 4 areas dealing here with fiduciary responsibilities. And the unique application of fiduciary role when a court desires to hold the offending party in a transaction responsible so as to prevent unjust enrichment. The judge can declare a fiduciary relationship exists between the parties, even though the offender was in fact a trustee. Now, quite honestly, this is done quite often by the courts. Note also on here, senior employees may owe a fiduciary duty to an employer in some cases. So again, these are called unique applications, but at the same time, they are kind of common in our society today. And what kind of fiduciary relationships do we have? Well, conservatorships, guardianships, which come out of the legal court system, executors, which comes out of wills, administrators of estates, which comes out of wills or probate, board of directors of a corporation, retirement account advisors, which is relatively recently added to the list, retirement account administrators, doctors to patients, and I bet a lot of people were surprised at that, teacher to the student, persons of cloth when counseling, lawyers with their clients, CPAs, CFPs, and registered investment advisors. These are relationship type fiduciaries, which means you owed something. As a teacher to you, I have a fiduciary responsibility, but it's not the same as I would have as a trustee. Fiduciary accountability. Fiduciary is liable to account if proved to have acquired a profit, benefit, or gain from the relationship without express knowledge and consent of one who's owed the duty. In other words, if you make a profit off of it, I've seen where trustees would sell an asset to a friend who would buy the asset from the trust, and the trustee got a kickback. And that would be acquiring accountability, and because it's a circumstance of a conflict of duty and interest. It could also be a circumstance of conflict of duty to one person and duty to another person, or taking advantage of the fiduciary position. In fact, a good way to get in trouble is have 2 trusts and have them do transactions between each other. Those are all issues of fiduciary accountability. And that we looked at unjust enrichment in those. We have also conflict of duties. The fiduciary duty must not conflict with another fiduciary duty, such as representing more than one client and the interest of the client's conflict. So you have to be careful when you take on the fiduciary responsibilities. I know some of the financial planners supplement their income, or when they're getting started as a financial planner, they do it by being a trustee, working with lawyers because it gets them source of clients and gets them experience. You got to be careful you don't have a conflict of interest. Breach of duties and remedies. Conduct by a fiduciary may be constructive fraud when based on acts, omissions, or concealment, if considered fraudulent, dishonest, or deceitful. And that's a kind of definitional type that you should be aware of. Benefits gained by fiduciary in such a case would be returned to the principal because it would be unconscious to allow the fiduciary to retain the benefits. And there's an exception if full disclosure is made and the principal fully accepted and fully consented the type of course of action, and that has to be in writing. I know that more than once I've heard of fiduciary said, but I was told by the grantor. Well, you got to put in writing, and I think documentation is probably the biggest savior of fiduciaries from getting in trouble. You document what you tell your clients, you document what you do, and if you do that, it becomes very difficult for people to find you wrong, because in most cases you're going to be able to justify what you did. It's usually justifiable features, but they weren't documented to prove it. A constructive trust you have to be aware of. When there's a gain by the fiduciary is identified, the remedy is a constructive trust. And courts have created and imposed the duty on the fiduciary to hold the asset in safekeeping until it rightfully can be transferred to the principal. And going back to the example I gave you earlier, the fiduciary sells something to another organization from the trust. That organization gives them a kickback, we'll say of $20,000. That $20,000 has to be put in a constructive trust until he can get the assets back to the principal or the trust. Count of profits. Remedies used when the breach of duty was ongoing, or when it's hard to just identify the gain. Any profit made by fiduciary by virtue of the fiduciary position should be transferred to the principal. But if, right bluntly, the burden of proof is on the fiduciary as to whether or not they did or did not make a profit off of it by breaching the duty and getting a gain. And in 99.9% of the time, it'll be found against the fiduciary. Again, it's so important to document what you're doing and when you're doing it. And again, the other part of it is getting the permission of the beneficiaries, or if there's a grantor still has some controls to the grantor, and have that in writing. And it's similar to the constructive trust remedy, where you hold it for the benefit of the beneficiaries or trust. Compensatory damages. If establishment of profit is hard to determine, the principal will seek compensation damages instead, and that's true in most cases. To come up with what the exact profits were is only academic in nature. In almost every case, it's a subjective, because it's not just the dollars, but it's the interest involved and other things taken into account that are going to be supplemental to it, and the impacts it has on things. So damages becomes a much better way, because you can go get general damages, punitive damages, etc. Summary. In this module, we have learned there are many different definitions of fiduciary, depending on what your job is and your duties. There are many professionals that are fiduciaries that don't realize it, such as teachers. Most states use part of all the Uniform Trust Code, therefore you should be familiar with it. And there are a number of accountable activities performed by a trustee, and they are held liable for what they do. I might add again, everything should be documented by them, and if you can get in writing permission from the beneficiaries and or grantor if the grantor is still in control, such as a grantor trust.